And welcome everyone to Advisory Insights Emerging Markets webinar. Stuart Everman here, your host of our law firm. And we have with us our distinguished guest, Justin Morcone, who is counsel to Overman Law Firm and who is our resident cannabis, psychedelics, emerging markets expert. And today, Justin, I want to talk about the Ohio adult use. I know that is an emerging topic. We've got Ohio regulation. We've got the governor, outlawing certain things. And I really want to jump in there with your expertise and really figure out what's going on. And I know you've got the inside track where our viewers can really drill down on this. And so, start off, tell us what's the state of Ohio in adult use.
Sure. So just to answer your question, right off the bat, I mean, Ohio did pass adult use legislation. It was actually by constitutional referendum, right? So they posed a constitutional question to the voters. The voters voted to legalize adult use cannabis over 21. And then it was up to the legislature to come up with the law, right? And so that took some time. And there was a lot of wrinkles in kind of figuring that out. But they ended up coming up with a law that everybody could agree on. And they came up with a new regulatory body. So it's the Ohio Division of Cannabis Control, the DCC. If you hear that reference, that's what that means. And so they're going to be starting to roll out these new permits for adult use cannabis. And the first step in doing that is rolling out the current medical users into the adult use market. So typically, you may have heard from other podcasts, if anybody's watching, that when a market goes from medical to adult use, typically there's an initial round to get the market started where the medical operators can apply for adult use permits. And this doesn't mean that there's no more medical cannabis available. They offer medical cannabis as well as adult use cannabis. The products are the same, the taxes are different, and the fees are different. So that's what Ohio is about to do. And
so there was some talk regarding the D8, D10. And tell us what the governor did is as far as outlining or outlawing the intoxication.
This is a hot topic, Stuart. You're aware. So Delta 8 and Delta 10 are synthetic cannabinoids that are created from hemp. In fact, they're created from the extracted CBD from hemp that a chemist then goes in and changes the isometric composition to mimic Delta 9. Then Delta 9, obviously the intoxicating substance of marijuana. And so they come out with different synthetic cannabinoids. And there's been a movement across the nation to limit the access and ban these products. You don't need a license to sell them. They are not regulated in any way. The testing on them is questionable. There are reports of sales being made to minors. So there's a big push to regulate this market. There's even a bigger push to regulate this market in states that already have medical or adult use cannabis programs. And so we've seen this in a number of different states where there's been legislative activity, there's been district attorney activity, just seizing products from different stores, making interpretations of the current law. And so in this case, in Ohio, Governor DeWine has come out and banned, right? He's pushing for the banning of these intoxicating hemp synthetics, right? These cannabis synthetics and these Delta 8, Delta 10, there's Delta 11, there's HHO, there's something called THCA, right? There's elements of Delta 9, right? So Delta 9 also exists in hemp, right? And the standard is it has to be below 0.3% on a dry weight basis to qualify as not being a Schedule 1 substance. So to get around that, they extract out the acidic version of Delta 9 THC in high quantities, right? Concentrated quantities. But as long as the acidic version is less than 0.3% on a dry weight basis, it can be sold as a hemp product. And the deal there is if it is below that 0.3%, as soon as it is heated, whether that's vaporization, inhalation by smoke, whatever it may be in the heating process, it converts the acidic and the THCA to a regular THC that your body can then digest and you get the euphoric effect. So there's been a push in these states that already have a medical or adult use market to limit or ban those products because they are inhibiting the profitability of the current operators in either the medical or adult use.
Well, I know you published some articles in our newsletter regarding these particular states, which is enormous reading. And for those who are watching the webinar, if they don't belong to our newsletter, and we can give the information at the end, it'd be fantastic. So I know there's some critical dates coming up in Ohio. We've got June, July. Run through those dates a little bit, because those are critical.
For sure. And again, you're hitting the nail on the head with this, but the conversion of the medical to adult use, you have to be critical. So it's not automatic, right? These current operators have to apply to the state. And so June 7th is the date they've come out with, where they're going to release these applications to the current operators. And usually what we see when there's a release of application is anywhere from a 90 to 120, maybe even 150 day window to review. In this case, they've set a date of September 7th, 2024 to make a decision on granting those permits. So we're going to have a large run up to June 7th when the application is released. We're going to have a busy summer, and then we're going to be able to submit. Likely the turnaround time between release and submission is usually 30 to 45 days. So all the submissions will be completed by mid-July. And at that point, the DCC will just be taking them in, scoring them appropriately, and then releasing the results. And they've given themselves till September 7th to do that.
Well, I know that they're looking at 40 level 3 adult use licenses, and then there's another 50 potential dispensary licenses. Is that going to drive the application process crazy?
Well, so it's a great point, and there's a footnote there too. So there are, believe it or not, you're going to get many applications. I mean, almost every medical operator in Ohio is going to apply for adult use, right? And so it is going to be competitive in some respects, right? And I should tell you, before I answer the question completely, that there will be another round of permitting for people who don't hold medical licenses yet in Ohio, and that'll probably happen in the fall. So right after that September deadline, it's likely that it will release additional permits: retail, cultivation, manufacturing, delivery, testing, you name it, in the current market. So anybody who's watching who doesn't have a medical permit, it's probably still a really good idea to get familiar with this in order to be prepared kind of for this next round. But to answer your question, Stuart, they are limiting the 40 of the level 3 and then the 50 adult use on the retail. The ways that an operator will distinguish themselves from other operators in the application round is certainly the content of their application, right? And that's our MO, right? We have a great track record of winning those permits. But another thing, and a large push in a lot of these different states with a lot of different legislation, is that they want to see some type of social equity and jobs program involvement by the operator. So if they can show that they've already been in a jobs program to help social equity people who have been subject to arrest or disproportionate impact from the illegality of cannabis, if they've already involved in something like that, and you're able to show that on the application, that's going to be a distinguishing factor that the DCC likely will award more points for, i.e. you'll have a better chance of winning that permit.
So have they made the requirements for the dual use public yet? And then how detailed is that?
Yeah, they have. And it's not dissimilar to something that we see in different jurisdictions, right? And so typically, right, if you are an operator, whether you're growing or retailing, in every jurisdiction that I'm aware of, and I think it's pretty much every one, you also can't have an interest, any kind of ownership interest, financial interest in a testing facility, right? In an adult use testing facility. And the reasons for that are fairly obvious, right? You can manipulate it. You don't want to get your product tested in the same company, et cetera. You also, all the states, of course, they all want to see your certificate of good standing with the taxing authorities, right? So to the extent you have some outstanding taxes from 23, I know we're coming up on a tax deadline. I know people do extensions all of the time. Sometimes they extend to June, sometimes till September. It would behoove these operators to get their taxes done before that June 7th deadline for sure, because you're going to have to get a letter saying that you are not delinquent in any of the payments of taxes for any prior years. That would include 2023.
Well, I know you and I previously talked about the 10-day receipts of these notices. How critical is that?
It is critical. So traditionally, it's a wonderful question. Traditionally, when you had a deficiency in your application, so you submit it, right? And say you said, oh, I'm going to take advantage. We were a member of this social equity jobs program, right? And we're going to submit evidence of that. But for whatever reason, the document wasn't submitted. It was the wrong document submitted. It didn't upload correctly in the PDF file on the online portal for the DCC, for instance. We've seen that a number of times. They'll issue you a letter that will say, hey, there's an issue, there's a problem with your application. You have a period of time to cure that. So in the past, right, and they've been doing this now for about 2 years across the states, but prior to that, you would be completely out, right? So if you missed a crossing of a T or a dotting of an I, your application was completely out and you lose. They've changed that. They've given you a limited window. Here it's a 10-day window, and usually it's something like that. It's a short time period to say, look, you have an issue with your application. Here's the notice just letting you know, right? We're not going to award any permits yet. You have an opportunity to cure that deficiency. And so typically they will come in, make that cure, and then the process will continue through the scoring of the application and the awards.
Earlier you mentioned the entity. So
Yeah.
what's some of these requirements for the new entities on the B10s?
Right. So when we talk about that, and the section you're referring to is just simply a reference to the regulatory section. So it's I forget the exact citation, but it ends in 10B. And so we're calling these 10B applicants. And essentially what that includes is people who are able to do both the dual use, so the medical offering, as well as the adult use offering. There are some preferences for that 10B, right? And so they're awarding 10B licenses, by the way, not only to current retailers, but also to current cultivation and manufacturers, right? And so there's a couple different criteria, right, for the requirements for a 10B. One is a level 1 medical marijuana cultivator, right? So that's they tier the different levels of cultivators, and so that's a level 1 cultivator with a certificate of operation or a provisional license. It's not a hard bar for a level 1 cultivator to get. They also get a level 2 medical marijuana cultivator with a certificate of operation or provisional license too. So you got your level 1s, your level 2s, and then on the cultivation side. And so then they put in the retail. And on the third criteria, it's the medical dispensaries, right, that are not commonly owned or controlled by a cultivator or processor. So they want the market, the current medical market, to be de facto vertical, right? So the cultivators, level 1 and level 2, will get a preference for a retail. And then the retails who don't have an interest in any cultivation and manufacturing will have a preference for the dual use on the retail, right? And so that's
You mentioned the initial round. So, I mean, how many licenses will Ohio issue on the initial round?
right. So, there's going to be, they laid out kind of the initial numbers, right? The 40 and the 50 that we talked about earlier. Those are movable. So, the discretion, right, of the regulatory body, of the DCC, if they don't, for instance, if they don't receive enough qualified applicants, they're not going to award all those permits. But by contrast, if they receive more than enough qualified and they want to increase the number, they're going to have the discretion to do that. And that's because of the constitutional referendum nature of the way that this law passed and the agreement on both sides as to what legislation would control. So they can dial up or dial down the number that they're going to ultimately give. But it's going to be limited, right? It's not going to be like a state like Oklahoma, for instance, where if you apply, pay the fee, you show the stuff, you're going to get a permit.
You're good.
And in that state, it's terrible. There's as many openings as there are closings right now in that state. And that's not how Ohio is going to be. It's very, very competitive jurisdiction. Yeah.
So what, we touched on some of the requirements in the B10 dispensary. So are they outlined what the requirements are for those applications?
Well, so yeah, I mean, there are some financial ownership requirements. Of course, you have the investment requirements aside from the laboratory testing facilities. There are also some setbacks, right, for where these things can be located, right? And so there's a 500-foot setback generally from all retail. from things like churches, public libraries, playgrounds, public parks, and schools. So when they get into, all right, we're going to issue you a permit, then you have to get into a bit of site selection and making sure that your proposed location meets the criteria for the setbacks. There's also a criteria that once you get into these 10Bs, that there has to be a certain number within mile radii, excuse me, of each other, right? They're 1 mile radii of each other.
Right?
Radii, so once the awards are issued, then there's going to be a significant period of time where there's going to be a site selection, right? And that becomes a very big point. It's something we do a lot of course, right? And so we'll help people understanding where real estate wants to be located. Do they want to lease or purchase? Do we get an option to purchase? Do we get an option on a lease? What are the if you're doing cultivation, right? Are we going to do some construction and fit out from the landlord if you're doing a lease on the different criteria that you need? And you can do a lot of cost savings that way too. So the site selection process is very important. Once you get over the hurdle of do you have a winning application or not, it gets into, all right, now where are you going to be and how much is it going to cost to get there? And we've made it our job to ensure that you do it economically and that it's a profitable business, right?
This could be a really, really, really expensive proposition. And, of course, everything's got a fee, right? Everything's got a fee. So what have they outlined a range of fees for this process? And is it refundable, non-refundable?
Right. I wish it was all refundable, right? So, but the states love tacking on fees and identifying, right, how many applicants can they get in and how much. So for these medical operators to apply initially, initially apply is not a fee, right? But after the cure letters come out and they start scoring the actual applications, it's going to be a $5,000 application fee, right? So if you submit something and you have no chance and you're not going to cure your deficiencies, then you're not necessarily going to have to pay. But if you move through the process, you will have to pay a $5,000 application fee. And to be frank, that's pretty much that's on the lower end of the application fees across jurisdictions. So we're fairly happy with what Ohio has done, particularly, and keeping in mind, this is for current medical operators. So the $5,000 fee for a current medical operator, they're in business already, right? They're a going concern and they should have some cash flows moving. So it's not like you are tacking on a fee to a new entrant who could be a minority, social equity, women, veteran-owned business who might not have the access to that capital up front, right? And all these things add up, right? But
I think one of the main keys, I think, and you guys are great at, is the retail selection process. Yeah. Because if that's not done correctly, that's an enormous costly provision. Right. So it's good to get the experts, loaded up front, if you will. Gosh, that's a lot of stuff going through Ohio. Is there anything else that you think our viewers want to know regarding this particular process in Ohio?
Absolutely. So let me speak to just two things. So in the medical side, right, even though and you just touched on it, the real estate selection process, even though you don't have to necessarily site select additional locations, right? So certainly if you're a current medical dispensary, you're going to want to identify that location, right, as your location. If you are a level 1, level 2 cultivator, right, with your provisional license, you have to look at what other locations you're going to get. And even though you don't have to necessarily identify all of that until site selection, it's a good idea to get in front of it and look at some potential towns, talk to their zoning departments, and understand where you could be located if you wanted to be in that town. Because in addition to the setbacks from the state, you certainly have to meet whatever local zoning requirements there are, right, in Ohio. And so if you can get in front of that and identify, all right, we're going to know this town. We may not know our setbacks yet because we don't know all the permit winners and where they're going to be for that mile radii setback. But at least we know this is the town and they've identified certain areas in that town will be accepted. And so I tell anybody looking at this, and those are medical operators looking for an additional retail, as well as new entrants, right? New entrants, they're coming up in the fall in these applications. I would say we're in March, we're coming into April, we're in the springtime now. It's not too early to start having these local conversations.
Well, this is why they need to get the experts involved. This is why you're way out in front of this. And if anyone wants to reach out to our newsletter, feel free to reach out. Email. They can email me, Stuart, STUART at obermanlaw.com. And I know we got some great stuff coming out. We've got more, webinars coming through, and just it's a never-ending process. It is a never-ending process. Justin, anything else? We certainly appreciate you, lending your expertise. I know you're very busy in this process all over the country, really. And next, we're talking about Maryland next on our next webinar. So this is a moving target, without a doubt. Without a doubt.
Well, I appreciate it, Stuart. It's excellent working with the Oberman Law, and of course, we had some great successes, and we continue to do so. I would say that we're very busy in New Jersey right now. We certainly have Maryland going to come up soon, and we'll be talking about that. And then in the psychedelic space, there's some fantastic things happening with that, and we'll talk about it in some future webinars as well.
Yeah, fantastic. Thank you, sir. We will talk to you soon.
Thank you, Stuart.